Good morning, everyone. Today we will discuss about the inherent powers of the High Court that has been provided in the section 482 of the CRPC. Inherent powers, there are certain issues with respect to section 482. The first is that inherent powers क्यों create करी गई हैं? When there has been a complete criminal procedure code, CRPC is there, then what was the requirement of saving inherent powers for the High Court? The second issue is क्या सिर्फ हाई कोर्ट के पास ही इनहेरेंट पावर्स हैं? If you will see that there are court of judicial magistrates, there are sessions courts also, whether they have inherent powers or not, or only whether it is the High Court that has inherent powers. Why the word nothing has been used and notwithstanding is used in section 482. So these are the issues that we will discuss in the course. Inherent powers of the High Court. If we talk about the inherent powers, what are inherent powers? Be it CPC, be it CRPC, you will find that in CPC that there is section 151 of the CPC which talks about inherent powers, and similarly in its counterpart, Criminal Procedure Code, section 482 is there. Whenever an act or code is created, be it CPC, be it CRPC, the intention of the legislature has always been to create a complete and exhaustive code. But since the circumstances are dynamic and keep changing, so it is not possible to define the law with respect to all the situations that are dynamic. The situations keep changing. So similarly, if the situations are keep changing, the law will also have to change. And therefore, to meet these circumstances, inherent powers in the CPC or CRPC has been created so that complete justice be done with respect to that particular case. The second issue is that High Court इन powers को कब exercise कर सकता है और क्या inherent powers जो High Court की हैं क्या वो CRPC की express provisions जो हैं उन पे overriding effect देती हैं या उनको or whether they are complementary to the express provisions of the CRPC. In section 482 you will find, I'll read the section 482. Nothing in this code shall be deemed to limit or affect the inherent powers of the High Court to make such orders as may be necessary to give effect to any order under this code or to prevent the abuse of the process of any court or otherwise to secure the ends of justice. You will see in this section that the first word that has been used is nothing and notwithstanding has not been used. Had the word notwithstanding has been used in place of nothing, then that would have created internal conflict between the powers of the CRPC, between the powers of the High Court and the express provisions of the CRPC, and would have given overriding effect to the powers of the High Court in comparison to the express provisions of the CRPC. Therefore, the word nothing has been used in the form of a saving clause. This section is a form of a saving clause, and this section, the powers under this section has to be seen as complementary to the express provisions of the CRPC. Now coming to the question, when such powers can be exercised? There are three circumstances. इसी section where you will see that has been the relevant part has been bold. तीन circumstances के बारे में बात करता है ये section जब High Court इन powers को exercise कर सकता है. पहला, to give effect to any order under this code. For example, under express provision of the CRPC, कोई एक कोर्ट ऑफ लॉ ने ऐसा ऑर्डर पास कर दिया है जो एक्सप्रेस प्रोविजन में था. अब उसको इफेक्टिव बनाने के लिए, उस ऑर्डर को ट्रू इफेक्ट देने के लिए एक सप्लीमेंट्री ऑर्डर की रिक्वायरमेंट है, और उस सप्लीमेंट्री ऑर्डर को पास करने के लिए देयर इज नो एक्सप्रेस प्रोविजन इन द CRPC. दूसरा, टू प्रिवेंट अब्यूज ऑफ द प्रोसेस ऑफ एनी कोर्ट. फॉर एग्जांपल, यू मस्ट हैव नोटिस्ड कि FIR जब होती है तो वो उसी एरिया में जुरिस्डिक्शन का, जब हम जुरिस्डिक्शन के चैप्टर पे आएंगे, कि एफआईआर वहीं पे लॉज होनी चाहिए जहाँ पे ऑफेंस कमिट हुआ है। बट फॉर एग्जांपल एफआईआर दो जगह लॉज हो जाती है, चंडीगढ़ भी हो जाती है और सपोज अहमदाबाद हो जाती है, दो जगह एफआईआर लॉज हो जाती है, तो उनको क्लब करने का या एक एफआईआर को उनमें से क्वैश करने का। और तीसरा सर्कमस्टांसेस जब हाईकोर्ट ये पावर एक्सरसाइज कर सकता है, और अदरवाइज टू सिक्योर द एंड्स ऑफ जस्टिस। The third circumstances, it is basically a residuary provision. The third part, कि पहले दो सर्कमस्टांसेस में क्या था, जो पहला एक्ट हुआ है वो एक्सप्रेस प्रोविजन ऑफ सीआरपीसी के अंडर हुआ है। अब उसको इफेक्टिव करने के लिए या उसका अब्यूज प्रिवेंट करने के लिए एक कॉम्प्लीमेंट्री सप्लीमेंट्री ऑर्डर की रिक्वायरमेंट है, जिसके ऊपर सीआरपीसी साइलेंट है। और जो थर्ड पार्ट है इसका, थर्ड सर्कमस्टांसेस जो हमारा है, टू सिक्योर द एंड्स ऑफ जस्टिस, इट इज ए रेजुडरी प्रोविजन, रेजुडरी पार्ट, जो जिसके लिए टू डू द कंप्लीट जस्टिस डिपेंडिंग अपॉन द फैक्ट्स ऑफ ए पर्टिकुलर केस, हाई कोर्ट कैन पास एनी ऑर्डर। The use of word nothing in section 482 and notwithstanding, I explained. The purpose was basically to make it a complementary and not to give overriding effect to the powers of High Court in view of the express provisions of the CRPC. Section 482 की powers तभी exercise होती हैं, has to be exercised by the High Court only when there is no express provision there. When the code is silent and to prevent the abuse of the process of court, or for the ends of justice, an order is required on which the CRPC is silent. Express provision of the CRPC will not affect the inherent powers of the High Court. As I mentioned earlier, inherent powers of the High Court and the express provisions of the CRPC are complementary to each other, और इन दोनों के बीच में कोई भी conflict नहीं है. Rather, the express provisions of the High Court, the powers under section 482, has to be used only when it is indispensable to do so. Only in the exceptional circumstances when there is no express provision and for the ends of justice, an order is required, and only then in those circumstances the High Court will pass order under section 482, and the High Court will exercise this power only in those circumstances. Only when it is indispensable to do so. Now, when such powers can be used, for which purposes can be used? As I mentioned earlier, there are three purposes which has been provided in section 482. The first is that to give effect to any order under this code. For example, an order has been passed, but that order has not been effective or has not been executed in a proper manner, and to make that order effective, a subsequent order by the High Court is required, and on that subsequent order, the CRPC is silent. And in such circumstances, the High Court will use the power under section 482 and pass that subsequent order. The second case when such powers can be used is to prevent abuse of the process of any court. For example, to quash one FIR in case FIR has been lodged within two jurisdictions or with two police stations, or to combine both the FIR. If you have noticed, हमने कई बार circumstances ऐसे देखे हैं, for example in matrimonial disputes, which is very common. Initially, parties के बीच में जब dispute होता है तो one of the parties go and lodge an FIR, but subsequently उनके बीच में compromise हो जाता है, be it matrimonial dispute or any other dispute. Now, it is not a compoundable case. Now, under what provision, if they want to compromise that case, they want to compound that case, how will they do that? Had it been the case of compoundable cases, they could have done it under section 3 under CRPC by filing a compoundable deed. For example, it is not compoundable. Then the parties approach the High Court to quash the FIR in that case, or to quash the criminal proceedings. So, to prevent the abuse of any process of any court, since the parties have already make make a compromise between them. So to prevent the abuse of process of any court, the High Court will use the power under Section 482 CRPC to quash the criminal proceedings or to quash the FIR. Or for example, we can say that when an FIR against a person has been filed and that person was not involved in any manner. For example, he was somewhere else when the crime was committed, and then in that case, that person can approach the High Court that since it is prima facie that I was not involved, so kindly quash the FIR against me. So in such circumstances, when it is seen that there will be abuse of the process of court, and to prevent such abuse, High Court will quash the FIR. Though there are separate guidelines how to quash an FIR that will have to be followed by the High Court, but this is the provision in which the parties can approach the High Court under Section 482. Now the third case is to secure the ends of justice. This part is residuary. Any order that is required for the ends of justice to do complete justice between the parties can be passed by the High Court. Inherent powers, as I mentioned earlier, are basically the power to do justice, to do complete justice between the parties. It is well settled that inherent powers under Section 482 can be exercised only when no other remedy to the litigant is available and not when a specific remedy is provided by the statute. As I mentioned earlier, Section 482, the powers under Section 482 can be exercised only when there is no express provision in the CRPC with respect to that matter. अगर कोई express remedy दे रखी है, if there is express remedy has been given, express provision has been given for that particular situation, then उस situation में Section 482 की powers exercise नहीं होंगी. The golden rule for exercising powers under Section 482 is that the CRPC must be silent for that situation. There are plethora of judgments you will see in this regard, and in one of the judgments, it has been mentioned by the Supreme Court that this section is a kind of reminder to the High Courts that they are not merely courts of law, but rather courts of justice. Being court of law, they are required to follow certain principles. They are required to follow express provisions of the CRPC. But being court of justice, if a situation is silent, if an act is silent for that particular situation, then to meet those circumstances, Section 482 has been created to do complete justice between the parties. Section 482 जो है वो discretionary power हाई कोर्ट को देता है. मेरा राइट नहीं है या किसी भी पार्टी का ये राइट नहीं है कि सेक्शन 482 में जाके एज ऑफ ए राइट हम डायरेक्शन सीख करें उसमें. इट इज discretionary power of the High Court, and therefore the High Court may refuse to entertain the petition if the party has not approached with the clean hands. May refuse to exercise the powers. If the party must approach with clean hands. Now the last issue, whether only the High Court has inherent powers and not any other court. In this regard, there is a judgment, Sakeri Vasu versus State of UP, 2008 Supreme Court, and the judgment in that case was delivered by Justice Markande Karju. Agar if you will see that there are courts of magistrate, session courts are there. Now, we cannot say that they don't have any inherent powers. They are also courts of law. They are also doing justice, but where are the inherent powers for them? The question that arises. Section 482 expressly uses the word High Court and saves the inherent power only for the High Court and not for the Session Court and Magistrate Court. But still, it cannot be said that they don't have any inherent powers. The fact that they are court of justice in itself implies that they have some powers which are inherent. But as held in the case of Sakeri Vasu versus State of UP, it is not proper to call such powers of Sessions Court or Magistrate Court to inherent powers. Rather, it would be proper if we call them ancillary powers or implied powers. Thank you.